as currency or something representing currency. Both of them are involved in this. So, if we're talking about currency, what other names do we give to that? Someone's printing money. We call it counterfeiting. That is also false token. Just depends on what state or what federal government agency is defining it. Okay? False token is a tangible thing. It is. Has anyone ever come across a counterfeit bill? Mm-hmm. You know, I came across one time. I picked it up. I knew it was counterfeit immediately because the ink came off in my fingers. Seriously, it was brand new. The person just passed it. And here's the dumb thing. There's a police officer standing right next to me, and I said, "Here, it was him." And he put him under. He cuffed him right there. He was caught with a whole roll of $20 bills. Why does this stuff always happen to me? I don't know, but it does. False pretenses. What would be a false pretense? What do you think a false pretense would be?
False situation, like, I think a pretense is like, if you had to say something like, I pretend like I have cancer or something, you know what I mean? Like, I put you under a false guise of what's going on. So, manipulation.
That's really good, Zach. That's an excellent one because that's been happening on a regular basis over the last few years, where mothers especially are setting up false accounts for and saying their children have cancer or some other bad disease, and they're actually then poisoning their children to make it look like they actually have this. So that's another kind of crime that goes along with it. But false pretense is where is the money that they're receiving in. Yes?
I have a question. So what is it called when a parent puts a light bill or something in their kids?
Fraud.
That's fraud. This never happened to me. My mom's not this type of mom. But
That could be false pretenses.
Oh.
It could be false pretenses. It could be fraud. It could be considered to be simple theft. Theft of resources. Yes. Yeah. Yes, I'm There could be a situation in which you are stopped for something under a false pretense. Yes.
Like if this guy like dressed like a police officer, I don't know.
Oh yeah, that's false pretense and then impersonating an officer of the law. That gets really serious. Yeah.
What about people that pretend to be homeless?
Pretend to be homeless. That's false pretense, and that's impersonating something. There's an impersonation there that is giving them a financial advantage. So yeah, it would be false pretense. Could be fraud, because they know they're not homeless and they're doing it anyway, right? That could be fraud. I mean, it depends on what the state law says of where this all fits in. This is not the same. The definitions we're talking about here can be slightly different in every single state. Okay? Fraudulent concealment. Fraudulent concealment. This is very similar to false entries. Fraudulent concealment. Fraudulent concealment. What happens if I take the daily receipts, bring them in, make false entries into one set of books, put the real amounts of cash in another set of books, and pocket the difference? That is fraudulent concealment, false pretenses, false entries, and forgery all at once. We're starting to get here toward racketeering. When you start getting that much stuff in one crime, we're starting to talk about racketeering. Mail fraud. Mail fraud. What is mail fraud?
Stealing somebody's mail.
It can be stealing, well, that's theft of mail. But you're real close. Opening the mail, that can be part of it. That can be one of the elements. Ever?
That was all that, on the ones that racketeering.
Send the mail to the wrong place.
So you said something about racketeering.
Racketeering.
Yeah, it's something, mail fraud is when you use the mail to perpetrate a fraud. People are using email these days. It used to be they'd send it through the U.S. Postal Service. If they're sending the fraud, like the letter that says you've inherited $6 million, well, give me your information at this number and I'll put it in your account. Make sure you give me your PIN number, your credit card number, and the secret ID number on the back. You know, when they ask you for all that stuff and it's through the U.S. Postal Service, it's mail fraud. There's another subpart to that, which is theft of mail, is when someone intercepts mail that is addressed to another individual and it doesn't get to them. And it doesn't matter whether it is, it's monetarily involved or whether it's a personal letter or a birthday card or what it is. When that stamp goes on it and it goes into the mailbox for delivery and it's stamped and everything goes through the system, it has to be delivered to the person who is there. So if we have if something happened and somebody who is picking up our mail someplace takes a piece of mail and says, oh, that's interesting, puts it in their pocket and walks away with it, that is theft of mail. And there's a whole host of mail-related infractions that can occur. Okay? Healthcare fraud. Healthcare fraud. What is healthcare fraud? Say you're on somebody else's healthcare and you give them the numbers and everything and you're not on there. Or a doctor bills for something he didn't do. That's healthcare fraud. You see more of the latter than you do the former. But that's healthcare fraud. Telemarketing fraud. Telemarketing fraud is when someone calls you on the phone. You get a lot of these calls that come from numbers that kind of look like they're from this area code or from your home area code. But they get you on the phone and they say, hi there, we've got the hot stock tip of the week. And it's not even a real stock. It's not a real thing at all.
I gave up.
You have that? That is telemarketing fraud. They know what they're doing. They know they're copying somebody else's number. They know that what they're selling you is just nothing. They're just trying to get all your information and steal your identity. And that's what we're going to talk about down here in a minute. Ponzi schemes. A Ponzi scheme is a fraudulent investment operation that pays returns to separate investors from their own money or money paid by subsequent investors. Bernie Madoff was working a Ponzi scheme where he offered high returns in investments on a fund which did not exist.
That was genius.
Yeah, that was
That was awesome.
To put something together like that was very intelligent, but it wasn't intelligent enough for him not to get caught. And what happened was the people who came in later figured out that they were paying their money in and never seeing the return he was going to give them back, and they called him on it. They called federal prosecutors and federal regulators and said, what's going on with this fund? And so that's what a Ponzi scheme is. They pay the high return it was going to his original investors, yes. But that's where it stopped. And everybody else was not seeing any of their money back. In fact, their money was disappearing because it wasn't a real investment. That's a Ponzi scheme. Check kiting was something that Mr. Mullendorf referred to. Check kiting is an illegal act of taking advantage of what we call float. Does anybody know what float is? I'm going to explain it. To make use of non-existent funds in a checking or other bank account. So here's what it is. And this is how it is working these days. Someone sends a check through the mail, which makes it mail fraud. They send a check through the mail and says, deposit this check. Go out, buy these items, send them to, you keep them, you earn the interest or you do something with that check, you send all the stuff, and then write me a check off your account for $3,000. So their phony check for $5,000 in there, your perfectly good check for $3,000 is being sent to them. You've lost $3,000. Their check is no good. That is check kiting. They're taking advantage of the difference in the time between you writing the check and them writing the check. Now there's another way to kite checks. If someone is running some sort of an investment fund and they send you a check for the monthly fund and they say, put this into our account and we'll give you credit for it. Now, you're going to be able to withdraw those funds the very next day. So you think they're okay, right? Well, here's the thing. Bank accounts earn interest every hour of every day. So the person who is owning the account that you're putting it into so that you can then download it the next day is earning interest on your investment between the time you deposit it and the time you withdraw it. And that's not legal. That is called check kiting. And it's a federal offense. Again, this is all what we call white collar or business crime. Pretexting. Pretexting is someone who steals your personal information to become you. So the person that walks up behind you in a line at a store like Target and has a magnetic card reader that reads all the data and information off of your credit cards is a pretexter. They are a thief. They are stealing your personal information. They then put that somewhere and somebody buys it and they earn the money off of that. Those card readers that they put on gas station pumps, where you put your card in and pull them out and you don't know that that little extra thing is on there, that is pretexting. Somebody is trying to steal your identity and your PIN number so they can access your bank information. That is pretexting. That's a very real thing. All right? The identity thief then is the one who buys that information and becomes you. So they may buy a photo ID from the pretexter and a phony credit or debit card, and then they start using it. So they're the identity user. But it takes two. It takes a pretexter and it takes an identity thief. Okay? All right? Let's see how we're doing. It is 20 minutes of 7. I think you should be able to have, how many of you have not had dinner yet? Why don't you go get something to eat and come back? And I'll see you here again in 20 minutes. In 20 minutes at 7 o'clock. And I'm going to pause. So we're going to start up again with talking about constitutional safeguards. Now, we talked about these before, so you know what they are. We're going to talk about the 4th, 5th, 6th, 8th, 9th, 5th, and 14th Amendments to the U.S. Constitution, because they all are involved in criminal judicial process. The exclusionary rule is evidence that is obtained in violation of the 4th, 5th, and 6th Amendments is not admissible in court. So how do you find what evidence is obtained in violation of the 4th, 5th, and 6th Amendments. It's generally evidence that is obtained without a warrant, or it is evidence which is obtained without a Miranda warning and without cause, probable cause. You must have probable cause. So all evidence obtained in violation of those amendments cannot be used in court, and the court will throw that evidence out. Yes, sir.
What if there is what if there was like the evidence, even if it was like without probable cause? What if there's like something that the government needs to utilize and take effect on? Do they still throw it out? Like, for example, if this was, and if this had offshore accounts where they were receiving money from like illegal places, right? And the tax IRS is coming audit, right? But they had no probable cause of doing that, but it can endanger financially to the institution. Like, can the court still say, we have to take this into account?
Yeah, they can still throw it out unless there are certain emergency rules in place which would allow it to be utilized.
Are these emergency rules the second backup if the probable cause wasn't followed by the?
If that is kind of a backup to the probable cause argument, but most of the time it doesn't work because most cases aren't that complicated. Okay? The exclusionary rule is also known as the fruit of the poisonous tree because once the tree is poisoned, all of the fruit shrivels and dies. And you'll hear that on TV. They'll mention fruit of the poisonous tree. You all know what the Miranda Rule is, okay? What is it? What is the Miranda Rule? And who was Miranda?
Wasn't it the announcement of the law enforcement when?
It is what law enforcement announces when they make an arrest of a suspect.
Mhm.
So, who was Miranda?
Didn't it have to do when we were at war with Britain, like they came, like they were evading?
Oh, this is much more recent.
Yeah,
The Miranda Rule is much more recent.
I know what about it.
Miranda was an individual who was being arrested for a robbery, and he was attempting to get away from the scene of the crime. And the police took extraordinary measures to catch him and hold him. And he said that his right to due process was violated because the police did not accuse him of a crime before he was taken to the county lockup. So the Miranda Rule says, and we'll go ahead, and no, I'm not going to go ahead. I'm going to stay with this. It works by saying that they have a right to remain silent. They don't have to testify against themselves. That's the Fifth Amendment. They have the right to the presence of an attorney. That's the Sixth Amendment. They have the right to the appointment of an attorney if they do not have one. That's the Eighth Amendment. And they won't be questioned without the attorney. That's back to the Fifth Amendment and Fourth Amendment. Okay? That's how it works in the United States. What do you think would happen if we were in Great Britain?
Like if we lived in that country?
Yes, if you were in Great Britain, either visiting or a resident,
It doesn't.
Will we
It
still be
changes.
like that?
it changes.
Yeah, because
Yeah.
they don't practice what we practice here in the U.S. They actually don't need to do that, right?
So we get sent back.
Pretty much. Go ahead, Tree.
We get sent back to a new life phase.
Well, the way it works in Britain is that if you have an alibi, you have to tell them what it is when they question you immediately. Because if you don't, then you can't use it in court. So you don't have the right to remain silent. You don't have the right to the presence of an attorney. And if you don't have an alibi, you have to end up getting thrown into the local lockup. And your alibi has to be stated right then when they arrest you, or you can't use it during any court proceedings. So there's a big difference in Great Britain and in the United States. What is the Miranda Rule and the Fifth Amendment allow? What does it allow? And why and where does it apply? Well, it applies in a coercive environment that is generally defined as somewhere in police custody. So that would be in the presence of police interrogators, at pre-interrogation lineups, at the time of arrest, during trial, and at sentencing. Now, what I mean by listing all of these is that they don't just read the rights to the suspect and the individual they have arrested once. They read them to the individual in the presence of an interrogation and a lineup. They read them their rights. In fact, back when I was first practicing law, I was asked to step into a lineup room where the individual attempting to identify a perpetrator was, and act as the perpetrator's attorney while the lineup was going on for identification purposes to make sure that his rights were not violated. That was my only duty as the attorney at that particular point in time. That's all I did, was I stood in that room, made sure they did the lineup correctly, and it was over. They either did or did not identify the individual, period. But they read the individual his rights before he went into the room and stood on the platform with the heights measured off on it, where they show the lines, like on TV, where they show the lines and the height and everything. So that was the pre-interrogation lineup. And they, in fact, do have an attorney present for him at that. At the time of arrest, we've all seen that, where someone's put under arrest and the police officer pulls the card out, or the detective pulls the card out of his shirt pocket and reads them, actually reads that card. When you see it on TV and they're just telling them what their rights are, that is procedure, a violation of procedural due process under the Fifth Amendment. They are required to take out the card and read it. The reason I know this is that when I was in the Army, and I acted as an officer on the scene of arrest for the military police for the Criminal Investigation Division that I worked very closely with, I had one of those cards that I carried in my pocket. I still have that card. And it's in with my memory stuff. Yeah.
How do you pull up a liability thing, or do you just what's the reason behind it?
It's because the wording of the rights has to be specifically stated so that they don't miss anything. That's why they read it off the card. And if I think about it and you want to see it, I'll bring my card in and let you see it. It's just as taught. A small card, 2-point type, but it has everything on it. So they read that card in the presence of the interrogators, at pre-interrogation lineups, at the time of arrest, at trial. Did you know they read them their rights every day before they go into trial? Do you know why they do that? In case you forget, and do what?
Say that it wasn't given to you at the time it was supposed to.
Well, that doesn't cure not doing it at other times. But it prevents you, or hopefully prevents, the defendant from doing what? Incriminating himself, getting up and yelling something at one of the jurors, and the trial can be over. they can declare a mistrial, and they have to do it all over again, and it spends additional resources, and they have to choose a new jury, and everything has to start over right from the beginning. And then it's sentencing. Before a person is sentenced, well, there's actually one more time, but at sentencing, when they bring an individual in to tell him what his sentence is, whether it's probation or jail time or confinement to a mental facility or even death, they read them their rights and make sure that they're not going to any further incriminate themselves, because you may not think it happens, but it has happened that somebody has said something thinking they were going to be convicted and thinking that they were going to get one sentence, and they say something and it makes it more serious and they end up getting another sentence. And the judge can do that. The jury's already found the verdict, but they don't apply the sentence. It's the judge that does that. And heaven help us, I've actually seen it happen. And then there's one other time. It's when the sentence is carried out. So before an individual is taken to the penal institution in which they are going to serve their sentence, or before they are taken into the death chamber, they are again read their rights. There is the essence of the Miranda warning. Right to remain silent. Anything they say can be used against them. They may consult an attorney before speaking. If they can't afford an attorney, the court will appoint them one. If they don't have one available, they can remain silent until they are appointed an attorney. And then they have to ask them in plain English, now that I have advised you of your rights, are you willing to answer any questions without an attorney present? They have to give an affirmative answer, yes or no, to that. If they say anything other than, yes, I'll answer questions, it automatically means, no, I will not say anything. And they have to stop the questioning right then and there and make sure there's an attorney present for the individual who is under arrest and being questioned. Okay?
Hi, Fred. Do they actually have to stop the questioning?
They actually do. If there's a police interrogation going on and the individual right in the middle of it remembers he has the right to an attorney and he says, I don't want to answer any more questions now, I want to call my attorney, they stop. They actually have to stop and make sure that the attorney gets in there.
So in TV shows and stuff where they kind of keep pressing them a little bit, that's against the law?
That would be the fruit of the poisonous tree, and anything that they get in there gets thrown out. So, when an arrest is made, it must be made by a civilian police authority. This way, you say, well, you carried that as a military officer, and you worked with the military police in the Criminal Investigation Division, and yeah. But only for military personnel. Anybody, and this goes back to the Posse Comitatus Act of 1886, anyone who is arrested as a civilian must be arrested by civilian authorities. Military authorities cannot step in and make an arrest. That's because back in the Texas and New Mexico and Arizona territories, back in the 1800s, there was a lot of cattle thieving going on back and forth across the Mexican border. The Mexicans would come over and steal cattle from the ranchers on our side of the border, and then our guys would go back and steal them back, and it was just going on and on and on, and the ranchers demanded that the Congress send the U.S. military in there. And the U.S. military very wisely refused and said it's not a military action, it's a civilian action, it needs to be handled by civilian authorities, and so Congress enacted the Posse Comitatus Act that said the proper authority must make the arrest under all circumstances. And that is civilians by civilians, military by military. It requires a warrant if the arrest is to be made after the incident. So if the police do not see the individual perpetrate the action right then and there in front of their eyes, they have to go to a judge and get a warrant. Here's where this comes from. Back in common law England, an individual who got away from the authorities after perpetrating a crime was considered to be safe if they made it to their own home. And their home was considered to be safe, and the area around the home, which was surrounded by fences and by bushes, was called curtilage. Curtilage around the house defined where the authorities had to go back to the justice of the peace and get an arrest warrant. It was a writ that the judge had to sign saying they could enter the curtilage of the home, enter the home, and arrest the perpetrator. Same thing has carried down to today. If an individual escapes police custody and goes and is concealed inside their home or inside anyone's home, a civilian's home, the authorities must go get a warrant to enter the home to obtain custody of that perpetrator. Okay? Yeah.
When they bring the warrant, like if you're renting a home, do they have to bring it to your landlord or you?
If you are in the home, when they bring the warrant, whether you're the landlord or whether you're the occupant, see, the occupant is technically the legal owner of the property while they are renting it. So if the homeowner is there, it has to be presented to the homeowner or the renter. If the renter is not there, then it can be presented to the landlord, and the landlord can provide access. But it has to be done with the right warrant. The warrant has to be written correctly. We'll get to that in a minute. Before the warrant can be issued, there is probable cause. You have to have probable cause. That means either the police have to have seen it actually happen themselves, or they have to have people that said they can identify the perpetrator, or they have evidence that points directly to the perpetrator. In that case, they can go before a judge, swear out a warrant, make sure it's written correctly, and it can be used to obtain custody of the perpetrator. Oftentimes, warrants are not written by the police. In some places they are, and presented to the judge for signature. In most cases, there is an assistant district attorney or district attorney available on duty 24 hours a day who writes up the warrant, signs it, gives it to the police officer, they take it to the judge, and the judge signs it, and then they go out and obtain custody of the perpetrator. Innocent behavior. Remember I talked about innocent behavior? Innocent behavior is not sufficient for probable cause. Even if there's no time to obtain a warrant, probable cause must be present. However, Larry brought up a situation in which there might need to be an emergency provision. Emergency provisions are those which means that the evidence or the perpetrator might disappear more quickly than the police can obtain a warrant. A case I had when I was an attorney back in Columbus. Columbus is a state with a lot of forests. and there's a lot of illegal hunting that goes on. And there was an individual that was going out and hunting deer for meat, which he would sell off-season. You know, there's a specific season when you can take deer. And he was using a rifle to obtain this product and taking them back, butchering them, hanging them in a meat locker, a cold locker, at his home, which was surrounded by an 8-foot fence topped with barbed wire. I mean, he really had this down to a science. And the natural resources officers who had police powers tracked him to that particular compound that had the locker and everything. Unfortunately, the guy spotted them, knew they were tracking him, knew they were going to pick him up, and he was then trying to load the product into a trailer so that he could move it out of there, and he almost made it. But the Tennessee Wildlife, or the Ohio Wildlife Resource officers were able to obtain a method of entry into the compound and went in and arrested him because they knew that the evidence was going to disappear. Now, if the evidence is going to disappear, emergency provisions say that the police officers or constabulary that has the authority to make the arrest based on their law that empowers them may go in and make the arrest. Search warrants. A warrant can only be issued if the arresting officer appears before a neutral and detached magistrate. A neutral and detached magistrate is a judge appointed for that purpose, or a regular county judge who will have absolutely nothing to do with that case after that warrant's issued. He has no interest in it. So he'll fill out the warrant, sign it, and give it to the enforcement officers, and they will go out and carry it out and obtain custody of the perpetrator. Okay? So he's neutral and detached. He's not going to have anything to do with it again. It provides a description of the place to be searched. It is sufficient for the description of the place to be searched as being a house, address 123 Able Street, Nashville, Tennessee, zip code. That is a description which is considered adequate for an arrest warrant. And it needs a description of the things to be seized. Counterfeit Rolex watches. So if they're looking for counterfeit Rolex watches at 123 Able Street, Nashville, Tennessee, and it's signed before a neutral and detached magistrate, and all of these things are on the warrant, they can go in, obtain custody of the perpetrator, and seize the evidence, making sure they have a proper chain of evidence, everything signed in, everything labeled, everything put into the evidence lockers at the police station or the sheriff's department or wherever they're going to keep it, and it stays there, and everybody that goes in to look at it, bring it in or out of that evidence room, signs it in and out so it's not lost. Because if any evidence is lost, which is logged in, the case is pretty much compromised. Criminal procedure at pre-trial. First thing that happens is there's an arrest. They're read their rights. Then they're taken before a magistrate, which is a judge. We have a special judge down in the Davidson County Sheriff's Department that when an individual is taken into the jail for the very first time, he is brought before that judge and he is booked. That means take his name, address, his fingerprints, his photograph, he's read his rights, and the judge signs off that this has been done. Then we have what we call the first appearance. The first appearance is the first time that they actually appear in a real courtroom before a judge which is elected by the people of the state of wherever. They appear before him and the judge says, you are being charged with a crime against the people of the state of, we'll say, Tennessee. You are charged with hunting deer out of season, selling that deer, and attempting to illegally move that product across state lines. So they have all of that, and that is read to that individual at the first appearance, along with his rights, again. Then there is an indictment. All of the evidence that's gathered from the field, from the booking, from the first appearance, from the arrest, goes to the grand jury. And the grand jury returns what we call an indictment. It is also, in some places, called a bill of information. It sets out all the evidence, whether they think it should go to trial, and whether they think that it's going to be a successful trial. That comes from the grand jury. A bill of information, if the grand jury does not indict, can be written also by the district attorney, which says, here are the charges, here's the evidence, we think this should go to trial. So either an arraignment and an indictment, or a bill of information and an indictment. Then we have the arraignment, and the arraignment is the second time this individual appears in a real court in front of a real judge. Only this time, he's read his rights, he finds out who the judge that's going to try him actually is on behalf of the people, and they are given paperwork that they have to sign saying they waive their right if they're going to be extradited to another county, if they're going to be extradited to another state, they are arraigned, and then they are extradited if they're going to go someplace, or they are sent back to jail, and the arraignment is where they post bond. That also means that that is where bond is set. Bond depends on a lot of things. Depends on the serious nature of the crime. It depends on whether or not that individual is a flight risk, and whether he is a danger to himself or others. So it depends on all those things. At trial, in a criminal trial, the first thing that has to be developed is jurisdiction. Now, jurisdiction says we have the right to hold this person because this person is the one that we believe committed this crime. So they have in personam jurisdiction. Venue is when they declare that it happened inside the county in which the crime actually committed. So if the crime was committed in Williamson County, we can't try them in Davidson County. They have to be tried in Williamson County. Okay? Jurisdiction says we have the person who was under arrest and who has been arraigned and who has been indicted. Here they are, right here. Corpus Delicti. Corpus Delicti literally means bring us the body. It used to be that if there was a murder trial, they had to have found the body in order to have the trial. This is no longer the case. Most cases are developed without a body having been found. So Corpus Delicti has come to mean, do we have the right person? If we have the right person, then we can proceed with trial. What happens if we don't have the right person? We can't try them, can we? And here's what happens sometimes. There are some individuals that like to seek attention. Some people like to pretend that they are very important. And one way to make themselves important is to become the perpetrator of a notorious crime that everybody knows about, right? So they come in and they confess to that. This is why the police don't release all the evidence that they have as soon as it's developed. They always hold something back. Wisely, because there are going to be some people that come in who don't have anything to do with the crime that are going to confess to it. We call these people frequent flyers because they will do this repeatedly, time after time after time, and they repeat themselves frequently. Then we have to develop a burden of proof. At trial, the prosecution has the burden of proof. The burden of truth never changes. The prosecution must always prove its case beyond a reasonable doubt. The more serious the crime, the higher level of proof is required. But the burden of proof never shifts from the prosecution, ever. The level of proof in a criminal trial is one of two types: clear and convincing, or beyond a reasonable doubt. Clear and convincing is for lesser included offenses which are not as serious, perhaps misdemeanors that are close to a higher level crime, but are still misdemeanors. Clear and convincing. Beyond a reasonable doubt is the burden of proof that you're going to hear about the most often. Burden of proof says 98% of those jurors and 98% of the jurors must be convinced that this is true. So if we're saying 98% of the jurors, we're saying all of the jurors, aren't we? Why don't they just say all of the jurors have to be convinced and go along with the same verdict? But they say about 98%, just to describe things. Clear and convincing is about 75%, or 3/4 of the jury has to vote for conviction. Sometimes you will see on television a little banner underneath the news announcer saying, "And now the burden of proof shifts to the defense." It never shifts to the defense. The defense's job is just to raise reasonable doubt in the minds of the jury. That is it. Once reasonable doubt has been established in the minds of the jury, jurors cannot vote for conviction. So it never shifts. The burden of proof never shifts. However, if the defense is going to plead an affirmative defense, it has to prove, it takes on the burden of proof of proving the elements necessary to maintain it. Self-defense. There are elements to self-defense. The defense has to bring that up during their case in chief. They have to bring up all of the points and prove that their client did in fact defend themselves if it went to trial. Sometimes self-defense is determined in pre-hearing and people are just released, or even by the police or by the district attorney in conjunction with the police, and they're just released. But it can go to trial, and if they allege the affirmative defense of either defense of another, which that says that I can take on all the rights of someone else, like my wife. If I'm defending my wife from someone, I take on her self-defense rights on myself because I'm defending her. Or if I'm defending a child, or something like that. But I have to prove the elements necessary to maintain that defense all the way through my case in chief. All right? All of the defendants have a right to confront witnesses. Do you know of any time when a defendant does not have to confront the witness personally? There are a couple of occasions. Yeah, Jillian.
If it's a child or minor or something?
Excellent. If it is a child, when else? Anybody? And then I'll deal with those independently. If it is a child, is one time they do not have to do it, or when something happens in the courtroom?
No attorney?
Pardon me?
No attorney?
No attorney? Yeah, that's a third one. I hadn't thought of that one. That's a good one. When else? When the defendant is handcuffed, gagged, and pulled out of the courtroom bodily because they are misbehaving in court so badly that the trial cannot proceed. Then they don't have the right to personally confront the witnesses, but do they still confront the witnesses?
Private interrogation?
No? Well, sorta, kinda. For the child, we're gonna go back to that.
Oh,
No,
so just with the child?
Okay, let me finish this. Who is it that actually confronts the witnesses in the courtroom? The attorneys. The attorneys confront the witnesses. The defendant themselves do not confront the witnesses unless they are defending themselves pro se. That's what we call a defendant who defends itself without an attorney, a pro se defendant. P-R-O-S-E, pro se. They then ask the questions of the witnesses, and they have to do it correctly, just like an attorney does. Attorneys have years of practice of doing this. If it is a child, what happens with a child in the courtroom when they need to confront a perpetrator who may have, in fact, molested them or injured them? What happens to that child?
Frightens them?
It
Changes
frightens
their
them.
verdict?
It can change their testimony. It frightens them. They freeze up. They can't do anything. They can't look at anybody. They can't do this. And courts have done several things to make it easier for the child. The ones that are most usually used are remote deposition and questioning, where the judge, the attorneys, and the child and the court recorder go out to the child's home, and they'll sit under a tree or on the front porch, and the attorneys will ask the questions they would ask in court, and the defendant is not present. But it's a setting in which they can ensure that they're getting the most honest testimony from the child. Another technique which has been used very successfully in some courts is they will bring in an assistance animal, like a dog, who will sit next to the child in the witness box while the child is being questioned by the attorneys. This dog is trained so that if that defendant attempts to move from the defendant's chair, the dog will stop the defendant from moving until the bailiff can get there. Sometimes it's a deep growl, sometimes they'll get up and they'll confront the defendant, but they're highly trained and they always have a handler right there with them. But they're there to comfort and protect that child. That's been used very successfully several times. So the right to confront witnesses, primarily the attorneys, but the witnesses always have the right to confrontation. All right? With some differentiations in who the witness is and where it's being done. Constitutional safeguards under the Fourth Amendment is protection from unreasonable search and seizure. Well, what would be unreasonable search and seizure? Would be something where there was no probable cause. That's unreasonable. You had a question.
Yeah, absolutely. So what if the officer lies about having a gun?
They can't. They have to present the piece of paper. They have to present the piece of paper, or everything's going to get thrown out.
Okay.
They cannot say that they have consent to search or enter a building or a vehicle if they don't have that paper in their hands and present it either to the homeowner or to the landlord. Okay?
Two, I saw a video of the man, he got arrested, behind his mouth. I flagged that's not right. The judge was ordering him to duct tape his mouth, because he was sorry, he wasn't saying anything bad. He was defending himself.
It was disrupting the process of the court in order to get the information that was necessary to the jury or to the judge. They can do physical restraint. That was not unreasonable. I've seen zip ties, hands and feet. In fact, a year ago, I was in a jury selection process for an individual who had been driving a vehicle. He was convicted, so I can tell you this. He was convicted of driving a 18-wheel truck, fully loaded, up from Chattanooga, and he hit 4 cars and killed 10 people, including 3 children. And they couldn't get a fair trial in Chattanooga, so they called the jury here in Davidson County. And I was one of the ones they called as a juror. And we went through the jury selection process. And we had to write out, one of the things we had to do is write out a questionnaire about our backgrounds. And mine kept getting put to the bottom of the pile because I'm also a consulting attorney, and what I do is I read juries. And I know which way the jury is going to go during the trial based on testimony. Well, in that particular one, I knew which way the jury was going to go as soon as they were seated. There was just no doubt in my mind. And I don't know if any of them saw it, but one of the things that had me firmly convinced that there was going to be no trouble convicting this guy was he was wearing, they were trying to hide them, manacles around his ankles so he couldn't walk, he couldn't stand up, he couldn't run away. They were manacled, and he had a belt secured around his waist so he could not raise his hands above the table. So he was completely restrained. So those are not unusual restraints, but this guy was unusually dangerous to anyone in that courtroom. And it was funny because this is one of my good stories, just because every time mine would come up to the top, the judge knew me. I'd done some work down in Chattanooga, and he'd take it and he'd go, and he'd look at it and he'd look out at me. Out in the area where the public usually sits, he'd go, put it back at the bottom. And it happened so many times that the defense asked him why he was putting this one particular person back down in the bottom. And he said, I was a jury consultant. Any of you ever watched Bull, the TV show? It's on right after NCIS on CBS on Tuesdays. You want to see what a jury consultant can do. He has all the bells and whistles. He has computers and all that stuff. I don't do that. I don't have that. I do research. I will do shadow juries if I've had to, just all kinds of stuff. But what he does is he tries to figure out which juror is going to be approved or not approved. And every time somebody went up there and they started asking him questions, I was like, there's just no way this guy was going to be set loose onto society. Just no way. And one of the things, the defense gave away their entire case in chief right there in jury examination because they told everybody that he'd been on crystal meth when he hit these people. So he was beyond intoxicated. So anyway, I have been through this process myself on both sides of the rail. You know, most courtrooms are divided by a rail. I've been on both sides of the rail. I've seen it. And I was shocked when I walked in that courtroom and saw the placement of the tables for the prosecution and the defense. The prosecution was placed out a little bit ahead of where the defendant was sitting, and the defendant was parallel to the jury box. But that meant that all of the hardware that he was wearing was completely concealed. And that's the way they wanted it, because they wanted it to be a fair jury selection. And they had to keep that stuff on him, and they had like 4 sheriff's deputies in the room. And it was quite an experience. That was the only time I've seen that much restriction in a courtroom. Double jeopardy. You know what double jeopardy is? You can't be tried, found innocent, and then retried on the same set of facts. Other facts have to be developed that would lead to the same conclusion. And then you have to have a separate trial. But double jeopardy says it's over. Generally, it's just over. The right not to incriminate oneself is the Fifth Amendment, and the right to due process, which is either substantive, which deals with the right law, you're brought to trial under the right law, or procedure, which it means that you're using the right procedure. And it's done in the right order. Right to a speedy and public trial in the Sixth Amendment. The right to trial by an impartial jury of one's peers. Who are one's peers? Are my peers the same as your peers? Yeah, surprisingly, yes. Our peers are the same. Anybody over the age of 18 who has been properly examined by the court and found to be a suitable juror is a peer. Right to be informed of the accusations. So at the first appearance, they have to tell them what they are being accused of. The right to confront witnesses. The right to have witnesses on one side, which means we bring in character witnesses. We bring in witnesses that say, no, he was somewhere else at this time. No, he couldn't have done this because his car had blown up 3 days before and he was unable to get transportation. You know, just whatever, but witnesses. And then a right to counsel at various stages of the proceeding. It doesn't have to always be the same counsel. I was counsel for a guy that went before a lineup. Okay, but that was the end of it. Then he had his own attorneys that he retained who went through the trial process. Eighth Amendment, freedom from excessive bail. You can't keep the guy in jail for jaywalking. That is just totally excessive. Right? Makes sense? But if he's a flight risk and he's not going to appear in jail or in the courtroom when his time for trial comes, you may have to set bail a little bit higher. And they have a book that gives them guidelines on setting bail too. Freedom from excessive fines. I mean, jaywalking, $25, $50. You don't charge somebody $150,000 for jaywalking unless it's a very wide street. And then freedom from cruel and unusual punishment. What is cruel and unusual punishment? That varies with the society, the time of society, what the society is used to, what other defendants have had to be a part of, and what has been unusual historically or cruel historically. There's a lot of stuff reading about punishments and trials in Europe and England and other parts of the world that is just horrendous that we wouldn't even think of doing. Extension of the right to due process to all state matters comes from the 14th Amendment. So the state has to extend due process to individuals just the same way the federal government does when they're going through the judicial process. Extension of most constitutional rights to defendants at the state level. So all of the 1st, 3rd, 5th, 7th, 8th, 9th Amendments all apply also at the state level and have to be followed at the state level because they are applied through the 14th Amendment of the United States Constitution. The 14th Amendment covers states' rights. The 5th Amendment, the 8th Amendment covers federal rights and its application to federal procedures. So it's the 8th and the 14th Amendments. RICO. A couple people were asking me about racketeering, because I brought it up earlier. I said what racketeering is. What it actually is Racketeering, you can see what's up here, and I'm going to tell you how it really works. If we can get somebody to be charged with multiple smaller little things, like mail fraud, kiting, and fraud, we put those three together, and we can show that they're pretty much actionable for everything that we think they have done, we can charge them with the larger crime of racketeering. Why is that useful? Because the lower crimes might only have a maximum sentence of 3 or 4 years total for everything, but if we charge them with racketeering, the minimum sentence goes up to 26 years. Minimum. It is. This is mostly done on the federal level. The states have their own RICO statutes where the punishment is lower. Okay? And then anyone whose business has been damaged can recover treble damages and attorney fees in a civil action based on the RICO statute. And when we talk about torts next time, we're going to find out that there's a tort which you can sue for double or triple damages on. How are we doing on that? Everybody okay with that one? You write it down. Wait for Jason. Okay. So, False Claims Act. The False Claims Act is also a criminal statute which allows employees to sue employers on behalf of the federal government. That's a lovely statute for the federal government because the employee has to fund all of the attorneys and all of the actions and the filing fees and everything, but the federal government recovers all the money. And the person who brings it is out of pocket. So that's not really too fair. This really doesn't come up very often. And sometimes an employee will retain a share of the recovery and sometimes not, because sometimes the expenses can be way high and their percentage won't cover it. Sarbanes-Oxley. Sarbanes-Oxley is, for all intents and purposes, no longer effective. It has been legislated out of existence by executive order. President Trump legislated it out of existence.
I wonder why.
What it does is it passed by Congress in response to business scandals that we had, such as Enron, WorldCom, Global Crossing, Arthur Andersen. I know you all don't know about those, but those were pretty much corporations and individuals who owned corporations utilizing corporate funds for their own personal uses. And Sarbanes-Oxley was intended to get all these companies who are publicly held, that have stock and issue stock, to report on what they're doing on a quarterly basis. It criminalizes specific non-audit services when provided by a registered accounting firm to an audit client. That means that outside firms audit publicly held companies. It increases the punishment for a number of white-collar offenses. Those offenses have been reduced and they're now back to what they were before. And it extends the statute of limitations regarding discovery of fraud. It used to be a year for discovery, but now, and then Sarbanes-Oxley moved it to 2 years from the date of discovery and fraud and 5 years from the date of the criminal act. It may be back. It may not be back. The Congress has not done anything. They have not backed it up. So it could be back. We just don't know yet. Criminal liability. What are some of our defenses to criminal liability? Infancy. What do you think that means? Yeah, child, you're too young to know any better. There are three levels. One where the child is perfectly innocent, that's generally 5 to 7 years, depending on the state, and down. A level where they can prove, the state has to prove that they know what they were doing. That's from 10 to 14 years and down. And the last one is they have to prove that they didn't know what they were doing. And that's from 18 till about 14. So there are three levels of infancy. The bottom one is that they're totally innocent. And I've got a story about that. I know it's getting a little late. Do you want to hear the story or not?
I have a better one.
Yes.
It's some doing something. Yeah, yeah.
What about the kid who had who killed the people in the car accident, and his attorneys argued that he was so wealthy that he was never told no, so that was a reason of him killing them, and he was set free.
Yeah, that's kind of weird, and I didn't believe that for a minute. But the court,
How did they argue that?
I don't know. I would have to read the whole transcript of the trial, you know. But here's the one that I do know about with infancy. With infancy, there was a guy down in Chattanooga who was molesting his girlfriend very badly physically, beating her up, just terrible things. And mommy was getting really badly hurt, and this little 5-year-old boy knew where mommy kept the gun, and he got the gun and killed his boyfriend. They tried to argue that he was an adult,
All right.
5 years old.
Was he like,
Now, he might have known exactly what he was doing, but the statute said he was still an innocent, that he really didn't know that his boyfriend wasn't just going to be scared off, that his boyfriend was never going to come back. I'm sure he was quite relieved when he found out that he wasn't coming back. But the court was right, and the district attorney was just wrong. And in fact, the district attorney was voted out 6 months later in the general election, and he was replaced. Statutes of limitations. Statutes of limitations are in law, and it came from the old common law principle that you shouldn't have to look over your shoulder. If you do something wrong, you shouldn't have to look over your shoulder forever. So there are statutes of limitations for some crimes and some torts as well. And they go anywhere from a year for negligence to 5 years for white-collar crimes, up to there is no statute of limitations on murder. There's also no statute of limitations on kidnapping and rape in Nevada. So they can, and that they get the death penalty in Nevada. So there are different things around the country. That's my point for that. Yeah.
I heard that, I don't know, I think it's New York somewhere where they're making rape illegal.
What? Like there is no such thing?
No, saying that if a man, if they're not calling it rape no more, they're allowed to do it.
You mean marital rape?
No. I haven't heard from that, and that's Europe anyway, so we're not going to worry about it. We know what it is here. No means no. No means no. So there we are. Intoxication is the one after statutes of limitation, and intoxication is a defense. It is a defense because when someone's intoxicated, they do not know the nature and quality of the actions they are performing. They just don't know. If someone's blacked out or on the verge of blacking out or so intoxicated they don't know what they're doing, that's going to reduce the intent on any crime. On any crime. Insanity. This one is almost impossible to prove in court because the burden of proof on insanity is so great. If the defense decides to plead the affirmative defense and has to prove the burden of proof on the various elements of insanity, it's almost impossible to plead. Mistake means that, yeah, we made a mistake. I didn't know something, and it was a mistake. I didn't know if I signed Robert's name to this document that I was going to get $1 million and it wouldn't belong to him. I thought it would belong to him. So that's a mistake. Consent means, well, Robert gave me consent to sign his name on this and told me I could keep the $1 million, and so I did. That's consent. Duress. Duress is a little bit harder to explain. Duress is when somebody is forcing you to do something against your will. Well, that wasn't so hard, was it? Just like the woman who was a bank manager, she and her confederates stormed into the bank manager's house, took the family hostage, said they were going to kill them if the bank manager didn't take them down to the bank and open up the safe and give them all the money in there. Well, this is where nosy neighbors come in handy, because there was a nosy neighbor up at that hour of the morning, and that nosy neighbor was out walking their dog, and they saw this car, and they saw her being dragged off at gunpoint, and she called the police, and the police came out and stormed the house so that they were safe. And then when she went down to the bank to open the safe, the police were waiting there too. So, boom, it would have been duress. She would not have been held liable for bank robbery. Yes, Robert?
Is duress difficult to prove? Because there's like lots of situations where like people have said, like golfers or something put a gun to their head and was like drive the car, but then they still end up getting arrested for assisting in like a robbery or something.
Sometimes it's very easy to prove because there are other witnesses and other circumstances, and sometimes it's just as hard as what you just described.
Based off of that, as long as there's good evidence, it can be proven.
Evidence is the key. Witnesses are the key. Testimony is the key. Videotapes, home surveillance system, just whatever you can do to provide evidence just in case. All right? Justifiable use of force. Justifiable use of force is a funny thing. Sometimes it can be justified, and sometimes it can't. And I've starred this because if someone comes at you with a gun and is trying to shoot you with a gun, you can shoot them with a gun. If they come at you with a knife, you can still shoot them with a gun. But if they come at you with a baseball bat, you can't shoot them with a gun.
Wait, what?
Things have to go down. Things have to level out, and the force that you use to defend yourself has to be reduced as what their reduction in force is.
But if that would still kill me, so I can't like shoot him in the leg or something or just down him?
You will probably be arrested for aggravated assault.
But I can stab him.
This is true. This is more true than you know.
But I can stab
If you stab him, you still. More people are arrested trying to defend themselves with excessive force than we dare to think about. And it's true. It is absolutely true.
The bat is the ultimate weapon.
Your dog is the ultimate weapon. You know, but that little tiny thing that you have is not probably going to be it. When you get your little tiny Pomeranian, that probably won't be good enough.
I'm gonna get a pug, thank you.
Oh, you're going to get a pug? Okay, so the pug won't be vicious enough to protect you from 5 robbers at once, okay? Pugs are pretty cute. My nephew has 2 of them. All right. Entrapment. What is entrapment? Entrapment is when a police official puts an idea into somebody's head to do something illegal that they would never ordinarily think of doing. If a police official told me to go down and rob a bank, I'd like, I don't need to rob a bank. Why don't I want to rob a bank? They said, but you got to rob this bank. I'm like, no, I don't have to rob. Yes, you have to rob this bank. And if I were to go down and actually rob the bank because they told me to, and they were police officials, that's entrapment. They made me do it. You know? Wasn't there an old saying, is the devil made me do it? Yeah, so that's about what it would be. Immunity. Immunity from prosecution. Immunity from prosecution comes in 2 flavors. One is where one of the perpetrators flips on the, you know what I mean by flipping? It's when there are 2 perpetrators and one testifies against the other. That's called flipping. So when one perpetrator flips on the other one, then that guy can be given a deal by the district attorney either for a reduced sentence or not to face the same charges. that would give him immunity from prosecution at the same level as the other person they were actually going after. Right? Okay, the other way is if they are a operative of a foreign government. Operative of a foreign government is granted by our government freedom to do anything they need to do as an operative of that foreign government, because our operatives in their country is given the same privilege. Okay? And that carries on for however long that official is in this country, unless the ambassador withdraws the immunity. And I have seen several cases in which immunity has been withdrawn for a crime which was really rather egregious. Justifiable use of force is commonly called self-defense. Formerly, it could not be used if an aggressor attempted to disengage from the conflict, run away, or left home, or the area they had entered seeking the conflict. So normally, you used to be able to do that. Now, it's not so much. This has changed with the inception of the Stand My Ground statutes, where an individual can hold their ground if they're being attacked and can actually use deadly force. It varies state to state. Florida, Texas, Tennessee, Alabama, Mississippi, all have stand your ground statutes. So self-defense has become a somewhat different kind of statute. These are all the ones that have stand your ground. The dark orange ones have, or red, have stand your ground. The yellow have some that have passed them since Trayvon's death. And states that have proposed them are orange, but they have not yet been passed. Then we have federal sentencing guidelines. Federal sentencing guidelines are that book I was talking about, that for whatever has happened, the judge has certain guidelines that they have to follow in order to provide a sentence. That's to make sure that there is equitable justice for that particular crime, for those particular circumstances, all the way across, all defendants, forever. And then we have something called the 3 strikes rule. If someone commits a felony 3 times in a state, it's life imprisonment. That doesn't mean that if they commit a felony in Indiana and then go to Nebraska and then go to Texas and commit felonies in those 3 states, that they have 3 strikes. No, they have 1 strike in each state. You have to commit 3 felonies in a single state to be under the 3 strikes law. Okay? And that's it. Watch Canvas on Friday. I'm going to have your first writing project up. And it will tell you when it's done, where to submit it, and what day to submit it. Okay?
The assignment, this is the first assignment ever. No homework been given. Perfecto.
First assignment. Check on Friday. Check on Friday.
Right here.